Welcome to the Imagine in America podcast. I am Vita Ajamu, Chief Engagement Officer at the National Civil Rights Museum. Today, we're joined by two former federal judges whose careers help illuminate the court's historic and ongoing role in safeguarding civil rights, protecting constitutional freedoms, and upholding the rule of law. Judge Allyson K. Duncan made history as the first African-American woman to serve on the U.S. Court of Appeals for the Fourth Circuit, following impactful leadership roles at the EEOC. Judge James T. Giles served for decades on the U.S. District Court for the Eastern District of Pennsylvania, including in the role of Chief Judge. Welcome to the Imagine in America podcast. Thank you for being here. I'm going to go ahead and get us started with some conversation here. And I'm really looking forward to it and looking forward to hearing what you have to say, more specifically around this first question. What is judicial independence? And what is the rule of law? And if you could tell us why it is important.
It is interesting that that is a question that is often asked on citizenship exams. When people apply to become citizens, they're asked to define the rule of law, and some of the answers are very good. The ones I like the most say something to the effect that we follow the law and apply the law to the facts that are presented to us without fear and without favor. The rule of law is related to it. It means that we are governed by this, all of us are governed by the same sets of principles that are grounded in the freedoms that we enjoy as a result of the Bill of Rights. And it is to be distinguished from rule by law, which you have in dictatorships, for instance, where there's a law, but it is not fairly and evenly and justly applied.
Thank you for that. Judge Giles.
It is the principle that political agendas will not control the decision made by a judge. There's a world out there beyond the bench that is eager to have a decision in its favor and would be inclined to use pressure of various kinds on the decision makers on the bench if those powers could. And the inherited system of judicial independence coming from Britain and the rule of law is grounded so deeply in what we call the consciousness of fairness and decision making that it is the oath that is taken by every judge, state or federal, by which that judge is bound to do everything he or she can to be independent, separated from political pressure. And that means communicating to the public not to expect a decision based upon whatever is the societal or cultural norm at that time. If it's not law, then the court is not empowered to enact a law or create a law. the court must follow the Constitution, the laws as passed by the legislature, and any regulations that implement those laws. Without fear or favor, that means without consideration for whether the judge is going to be well off or not, even if it's going to mean danger. And there are dangers that come about because people expect a decision based upon what they want the decision to be, as opposed to what the law requires sometimes. And some people interpret a decision that upholds rights as being political, but really it's enforcing the Constitution.
Thank you so much for sharing that. Building on that foundation, Judge Duncan, how did your EEOC experience shape your appellate decision-making?
Well, it shaped it in ways that are profoundly practical. I spent 3 years of my professional life arguing Title VII, primarily race discrimination, gender discrimination, and religious discrimination in the federal courts of appeals around the country. And it was exceptionally powerful training. I think it also honed my writing skills, because I became profoundly aware of the economy of making your point straight and to the point and clear and move on. So I think part of the reason I like good writing, I always have. My mother she taught in the law school at North Carolina Central University. She taught legal writing and legal research. She would edit my letters and send them back to me. Wow. And I think it honed my writing skills to do that exclusively for that period of time.
That's great. That's great. Judge Giles, shifting from professional background to leadership. As Chief Judge, what leadership challenges stood out to you, and what innovations improved court efficiency?
Well, when I became Chief Judge, I think the expectation was mixed. Mm-hmm. Some thought I would likely not do well, and some thought I would do well, but all wished me well. And I'm speaking about the judges on the court. It was a large court, 23 active judges, and there were 13 senior judges who had full caseloads, and 5 more who had some association with the court but had not fully retired. So it was a large court. And the chief judge doesn't have power over other judges. But there were things that warranted discussion and achieving, hopefully, a unanimous approach to the resolution of it, or the way in which matters would be addressed by the chief judge on behalf of the court. We had weekly meetings, and the chief judge would preside at the meetings, and matters would be discussed. And conducting the meeting, being the leader in the meeting, sometimes was quite a challenge, depending upon the issue that came up. I'll give you an example. One was the question of whether a lawyer should be disciplined by our court, whether we should impose reciprocal discipline, that is. A state court had disciplined the judge, And we were asked under our rules to follow the discipline of the state court with respect to that lawyer. We didn't have to, but as a matter of camaraderie between the state court and the federal court, it was expected that we would follow it or have a good explanation for not. Well, the lawyer had criticized the Supreme Court justices of the state, and he had made statements that suggested wrongdoing, not criminality by the state court judges, Supreme Court justices. So the issue was whether or not the lawyer had a First Amendment right to make the statements. The other, of course, was whether we had a duty to say that the lawyer was wrong in the statements that he made because of the obligations that are imposed upon attorneys under the rules of professional conduct. So our court was divided on that, and trying to get a unanimous decision was impossible, as it turned out. And the judges that I had expected to support me in getting a unanimous decision were not supportive. Well, it wasn't personal. It was a matter of how they saw their role as independent decision makers. And that had to be respected, just as judges are expected to be, in deciding a case, independent thinkers, independent in the sense of articulating why the judge holds a certain position.
Understood.
And, that was a critical time for the court, and it was a learning experience for me. What leadership means, it means all those things you'd expect, listening and so forth, as opposed to making a decision for other people.
Great. That brings us to a broader constitutional framework. How do federal courts uphold separation of powers amid political pressure and public skepticism?
Oh, that's a tough one. They do their best to make their decision, to ground their decisions in the language of the Constitution and explain it to the best of their ability and hope that it will be widely and correctly reported. And I will probably just go, in my personal capacity only, I'm not speaking for anyone, I signed on as a retired judge to the amicus brief in the tariff case in the Supreme Court. I don't have my copy of the Constitution with me. Usually I walk around with a little pocket-sized version of the Constitution. Give a lot of them out too. And I thought the language was quite clear, but there's a tremendous amount of fallout. But the judges decided what they thought the Constitution said, and they accept the fallout that comes with that and I hope, and I think one of the things we're trying to do now is to inform people, to tell people, to enlighten people about what courts do, what our marching orders are. We don't march to the will of the executive. We don't respond to the will of the people. Our job is to uphold and protect the Constitution of the United States. And it doesn't always work out the way people would like, but that's why we're here. That's why we have life tenure. We're the only branch of government that does.
Yes. Judge Giles, would you like to chime in?
The first case I had as a district court judge involved the firing by President Reagan of the air controllers, air traffic controllers. And here I am, a black judge, young, short. The courtroom is full of people who want a decision against Reagan because they didn't like Reagan, or in favor of air controllers because they wanted planes to fly. The question to me was, what was the power of the executive branch? That was a simple question. And I gave a simple answer. There wasn't any fallout to me personally as a result of it, but that was my first separation of powers case. And it was a straightforward case as far as I saw it. Politically, people saw it differently. But from the judge's point of view, I was required, no matter what I thought, to say what the Constitution required me to say. And I did. I didn't write a long opinion. I didn't write an opinion, as I recall. I think I gave an oral opinion.
Okay. But we can't, I don't want you to get the idea that it's always that simple.
Right.
The law, you have two lawyers on each, you have a lawyer on each side, because a lot of the questions are very, very difficult. And I think what we have to do as judges is bring to it an open mind and a willingness to listen and to hear what the lawyers are trying to tell us, and try to come to a decision solely on the basis of those facts. Not facts we bring in with us from our experiences, but the facts that are presented by the attorneys. And that can be very difficult.
Right. And that's very important. To that point, let's turn to public understanding. You touched on that, right?
Yeah.
But public understanding of the courts. How should judges communicate with the public about the role of the judiciary after leaving the bench?
We don't.
Okay. And where my next question, the next part of it, the remainder of it rather, is where are the boundaries, right? So you just said you don't.
We're not teachers. We speak through our opinions, and that means we speak to the issue that was presented on the facts presented by the two lawyers in front of us. We don't stand up and speak ex cathedra. And so schools have an obligation, as Justice Sandra Day O'Connor said over and over and over again, to teach civics so that people understand what their government does. And it's just amazing to me, the number of people who don't. And I get some of the most mind-bogglingly, well, some of the questions, for example, I asked a person once who was fussing about ICE agents and what's wrong with what they're doing. And I said, do you know the difference between an administrative writ and a judicial writ? Not a clue. Not a clue. A judicial writ is issued by a judge, and it comports with the probable cause requirements of the Fourth Amendment. An administrative writ doesn't. It makes a difference. So if you're going to opine about something that is done, please have a factual basis for it. And I think that's part of what we're trying to do here.
Exactly. I think it's important for you guys to be able to teach and share. And you speaking of what used to be or what should be in schools is not necessarily there.
No,
so
it isn't.
Right? Right, it's fair to say. So sometimes having conversations such as these are important for people when they're just wanting to know or thinking that they have the right answer and not really sure about it. Yeah.
But we're retired.
But you're retired.
That's why.
Exactly, exactly.
But there's an opportunity in the public
Yes.
to ask questions about the judicial independence understanding
Right.
of any judge any candidate who's likely to be elected or appointed. There's a confirmation process through which the question can be asked, what is your understanding of judicial independence? And get an answer. What is your understanding of the rule of law? And get an answer. There is a proper political process to testing the commitment of the judicial candidate before the person is on the bench. Once the person is on the bench, it's a different proposition. But there is a process by which it can be asked. Every federal judicial nominee goes through such a process. But the public should expect that. Not just the process, but should expect that it's their right to request, to demand of their representatives that they question the candidate, not about how the person would rule in a case, but whether that person is committed to the oath that the candidate will take.
Yes, thank you for that. Reflecting on your time on the bench, looking back at major civil rights cases, what common thread in civil rights interpretation still matters today?
Well, I'd like to go back to judicial independence and talk about growing up in North Carolina before Brown versus the Board of Education was decided. My hero was Julius Chambers, a civil rights lawyer who argued the Swan versus Charlotte Mecklenburg school desegregation case before the United States Supreme Court. And so the Legal Defense Fund told him that when you get up in the morning and you start your car, leave the driver's side door open. If there's a car bomb, you might escape death by being blown out the side. We don't have to do that because federal judges in the South, by and large, followed the law. There was a Judge Ware. We were talking a few minutes ago about Judge Ware. His wife was spat on. There were bricks thrown through his living room window. They received one threat after another until finally they had to move out because he said, it is not just that racial discrimination is immoral. It is illegal. And he stood by that, and he paid a high price for it. That's what you call judicial independence. And that's why I get so frustrated when people say something about judges just don't follow the will of the people. And I want to say, well, duh. They're not supposed to follow the will of the people. They are structurally contra-majoritarian. They're supposed to serve as a block against the ability of the majority to crush the rights of the minority, of those individuals whom they outnumber.
Okay. Judge Giles, would you like to respond?
What decision I think controls how I think?
Right, the common
I would
thread.
say Brown v. Board of Education,
Yes.
in that it said what was plainly rational and logical, and that is that separation of people by law, by state, is inherently unequal. It's a violation of the Equal Protection Clause of the Constitution, of the 14th Amendment. It's just, you can't do it. So that's a principle that applies beyond Brown public schools. It's the way in which a person should look at what's being presented in a case. Is there, inherent inequality in the way in which the dolls, if you will, are being presented to the court.
Yes.
And I'm sorry, but no, you can't bring up Brown without my trotting out the fact that the Chief Justice cajoled, he pulled in every favor he could to get a unanimous opinion. He wanted it to speak for the court. And President Eisenhower was at Camp David, and he did not support the decision because he said the country's not ready. But when the decision issued, he flew back to the White House to stand in the Oval Office to speak to the nation, to say, the Supreme Court has spoken, this is the law, and it will be honored and upheld.
Okay. So finally, for our listeners, I'm going to go back a little bit to what you said about civic and learning. Mm-hmm. So for civic learners, how can people read judicial decisions with nuance in a politicized media environment? I know that's a big one, right?
Mm-hmm. You first.
Judges usually write what they mean.
Mm-hmm.
And it's important to read what is written to get any nuance, and not rely upon interpretations over social media. Mm-hmm. Every person capable of reading is capable of understanding a written judicial opinion. It's the obligation of the judge to write plainly, or plainly enough. So there are differences in judicial philosophy to justify how one interprets the law or congressional legislative history. So on some things there could be nuances. On other things, though, it's just clear what the issue is that's presented to the court, and I suggest how the court should decide it. You know, if the Constitution says that you can't bust into a house without a judicial warrant, then you have to get a judicial warrant to do that. If the law requires that there be a due process hearing, then there has to be a due process hearing. So those things, to me, are black and white, and I would view with deep scrutiny a decision that says there's some gray area. That's my non-judicial point of view.
I'm sorry, but it's also the perspective of a district court judge.
It is.
And I would have been I have been told this, I would have been the worst district court judge imaginable, because a lawyer would object and I'd say, let me think about that. On the one hand, but on the other hand, it's very hard for me not to see gray. And I think it's a difference in, you're good at it. You've done it. You trust your judgment. I kind of go back and forth an awful lot.
Well, district court judges do as well. But on some things, it's just not, it's so plain that you can't, you have to rule that way. It's like prayer in schools. There was a judge in our court, highly respected judge, a white judge, a Quaker, who decided some time ago, as a district court judge, that children could not be compelled in a classroom, public school classroom, to pray. It was their right, the students' right not to. I mean, he saw it as black and white. The Court of Appeals wrote about it. The Supreme Court wrote about it. But it was, from a district court point of view, the child was seen as having a right, just as others had a right in the courtroom, in the classroom, to pray or not pray. And it wasn't taking away some other person's right. It was recognizing the right of the child. Yes. And so some things are black and white. And certain civil rights are black and white. It's not a matter of debate. And I think that's what we see here in the Civil Rights Museum.
Absolutely.
People standing up for what is right. It's not debatable, although it was politically frustrating and so forth. They were energized because it was their right to be treated as human beings.
Well, Judge Duncan, Judge Giles, thank you so much for being here with us today for this very important conversation. I really appreciate your time. Thank all of you for joining us for this conversation on Imagine in America podcast. Subscribe and follow us on imagineinamerika.org and also on our social media platforms. And be sure to engage with us in our conversations to inform, challenge, and inspire. Thank you.
Today's episode is brought to you by the National Civil Rights Museum, located at the Lorraine Motel, the assassination site of Dr. Martin Luther King Jr. It chronicles key episodes of the American Civil Rights Movement, examines today's global civil and human rights history, provokes thoughtful debate, and serves as a catalyst for positive social change.